Good afternoon, everybody, and welcome to the Burgess Salmon Scottish Case Law webinar update. I'm delighted so many of you are able to join us this afternoon. Paul's obviously done the housekeeping, so I'll move on quickly to what we're going to cover before passing over. And we've picked what I hope are some of the more interesting planning cases over the last 12 months or so, and included a number of cases from England and Wales that have broader application and relevance in Scotland. And what was something of a vintage year for planning judicial cases in Scotland, in terms of numbers at least. We'll look at cases that deal with both development planning and development management, as well as appeals, and of course, national policy and SPP. And as Paul has just said, we have an exciting innovation in that we will be asking you to participate during the webinar with some interactive polling, and I think that will hopefully provide something of an insight into how these court decisions are viewed by those of you who are involved in planning on a day-to-day basis. And again, as Paul said, we will be having the usual Q&A function. Do please put your questions in there, and we'll try and answer as many of them as we can during today's session. And if we're not able to answer them today, we'll certainly try and get back to you. I am delighted to be joined by my two colleagues, Alex Mcintyre and Lindsay Reid, for today's session. Alex is a director in our planning and CPO team, and he specialises in the consenting of major infrastructure projects, CPO and minerals development. Lindsay is based in our Edinburgh office, working alongside myself, and Lindsay's been involved in a number of high-profile planning cases in Scotland in recent years, as well as judicial actions such as the Gladman JR case. And Alex, I believe you're going to kick off, so I shall pass over to you if I can.
Craig, thank you, and good afternoon, everyone. During this first section, I'm going to look at two cases which go to the issue of flexibility. What can be done with the permission which has been granted? What flexibility is there? And where can the benefit of what has been granted potentially be lost? Our first case is an example of a developer who appears to have lost the battle to maintain flexibility in the development of their site by virtue of inconsistent overlapping consents. There are many occasions where a development site is subject to more than one consent. The practical reality of development, especially on large-scale projects, is that circumstances change over time, which often leads to multiple consents being granted on the same site, and then confusion over which applies. The Court of Appeal case of Hillside and Snowdonia National Park Authority is a case where a decision has been taken in relation to a number of detailed planning permissions, described as variations, but each a detailed planning permission in its own right, which may have serious implications for the way in which sites are built out in the future. Hillside, the appellant, was seeking to rely on a permission which was granted in 1967 on a site in Snowdonia National Park. That permission was for 401 dwellings with a site-wide detailed master plan, and only one condition relating to water supplies. It was a detailed planning permission rather than an outline or a permission in principle. Now, a lot has happened to the site following the 1967 permission. Before 1987, 6 additional permissions were obtained for small variations to the original master plan. Those were the subject of proceedings before Mr. Justice Drake in the High Court in 1987, who determined that they authorised modifications of the previously approved development, and critically, the 1967 permission remained capable of implementation. 8 additional permissions were then granted and subsequently implemented from 1996 through to 2011. The LPA, the Local Planning Authority, now being the Snowdonia National Park Authority. In 2017, that same National Park Authority indicated it no longer considered the original 1967 permission as being capable of further implementation. So a departure from the Drake judgment, and its own previous planning decisions. Hillside sought certain declarations from the High Court about the previous judgment and the status of the underlying 1967 permission. Its appeal to the Court of Appeal has been dismissed. In reaching its decision, there were certain findings of fact in the High Court which were determinative. So from 1996 onwards, the permitted developments were materially different to the original master plan. As a matter of fact, certain elements of the 1967 permission were no longer capable of physical implementation. As an example, an estate road had been built in a location which cut across a row of terraced houses included in the original 1967 master plan. Now, I expect you'll recognise that language of permission being physically incapable of implementation as being the Pilkington principle, which has long regulated overlapping planning permissions. As a finding on the facts of this case, I would suggest it's relatively uncontroversial. However, there are two themes in the judgment of Lord Justice Singh which are giving rise to some concern within the development industry. The first is his acceptance of the submission that was put to him that the House of Lords decision in the case of Sage requires a planning permission A to be construed as a whole and B to be implemented in full. The second is the commentary which flowed from his consideration of what is referred to as the Lucas exception, a category of planning permissions which are said to comprise permissions to develop land as a whole or for any part of the development comprised within it. Lord Justice Singh declined to overrule Lucas, but made it plain that the decision had to be seen as fact specific. He also observed that it is unlikely to apply to a typical modern planning permission for the development of a large estate such as a housing estate. Matters which were not addressed in the judgment, but in my view fall into any wider consideration of the point, are firstly the role of Section 106 or Section 75 agreements for modern planning permissions in ensuring that a developer is not able to pick and choose, which is the concern that Lord Justice Singh had, which elements of the permission are in fact delivered. So it's not just the good, the profitable bits, it's the parts which are aimed at wider purposes such as schools or whatever the case may be. The second point is completion notices under Section 61 of the 1997 Act. What is their purpose if planning permission must be built out in full to be lawful? The third is the issue of detailed planning permissions as compared to permissions in principle, and whether a different approach is required of each. Now, we suspect this particular case may run on. The last we heard, an application for permission to appeal has been made to the Supreme Court, so this is probably one to keep an eye on. At this stage, we're going to move to the first of those polls that Craig mentioned and the first of our technological innovations, and see what you think might happen when we go up to the Supreme Court, if we do. So the question is, if permission to appeal is granted, do you think the Supreme Court will overturn the Court of Appeal's decision in Hillside? And the possible answers that we're giving you are no, because the Court of Appeal got it right. No, because the Court of Appeal got the ultimate substantive decision right, but the Supreme Court may choose to overturn the reasoning on Sage. Or yes, the Supreme Court will overturn the decision, and it will also impose its own reasoning. Now, while we're just waiting for the answers of that poll to come through, and while you're considering how you respond to it, we can ask ourselves what lessons we can draw from this case as it stands. The first, and the obvious one, is that where there are competing planning permissions, this decision is going to make it much more difficult for developers to keep their options open. On a strict application of the logic, there are many situations where careful consideration will need to be given as to whether it remains possible to implement a prior permission in full. The second, just before we come to those results, is that Section 42 variations, or Section 73 variations south of the border, would by and large avoid the issues which tripped up the developer at Hillside, albeit we recognise that Section 42 applications for large development sites are of themselves potentially problematic, which is the reason why the practice had emerged of dealing with this sort of situation by using detailed drop-in planning permissions to depart from site-wide permissions, usually controlled by a site-wide indicative master plan. Now, looking at those results, you can see the overwhelming feeling amongst participants on this webinar is that if we go up to the Supreme Court, the decision is likely to be overturned and the Supreme Court is likely to impose its own reasoning. And I think based on the number of people I've seen or heard commenting on this case in the legal press, the media, other webinars, blogs and so on, I think that chimes with the mood music which is out there on this case and the direction it may head in. So with that, we'll move on to our next case, which is it's old news. It's from 2019. We're potentially straying slightly out of scope of what was advertised. But when we're talking about Section 42 applications or Section 73 applications in England and Wales, it really would be remiss not to touch briefly on this case of Lambeth and the Secretary of State for Housing, Communities and Local Government, where the Supreme Court was asked to determine what the implications were of a planning permission granted under the equivalent Section 73 of the Town and Country Planning Act in England and Wales, which had failed to expressly include a condition that had been included in both the preceding planning permissions for the property. To give a bit of background, the original planning permission for a DIY store included a condition that the property could not be used to sell food items. In 2014, a further planning permission under Section 73 was granted. That 2014 permission did not impose a condition on the ability to sell food and made no reference to the previous permission's conditions. It did, however, rehearse the condition restricting the sale of food within the decision notice, albeit not expressing it as a condition per se. The developer subsequently applied for a certificate of lawful use for unrestricted use of the store, which was rejected by the local planning authority but overturned on appeal. By the time it got up to the Court of Appeal, that court ruled that the condition did not restrict the use, as the 2014 permission did not expressly state a condition preventing the sale of food. The previous condition no longer applied, Court of Appeal said, and therefore food could be sold at the property. However, the Supreme Court disagreed with that approach. Lord Carnworth indicated that the correct approach to the interpretation of words in a public document is to ask what a reasonable reader would understand it to mean in the context of the other conditions and the consent as a whole. That is an objective exercise in which the court will have regard to the natural and ordinary meaning of the words, the overall purpose of the consents, and any other conditions which cast light on the purpose of the relevant words, and common sense. That is the approach set down by the Supreme Court in the case of Trump International and the Scottish ministers. Applying that here, given the 2014 consent listed the condition in question, but didn't call it a condition in terms, the court had no difficulty in reaching the common sense view that the wording rehearsed as a varied condition was in fact intended to operate as a condition. It was all there on the face of the permission. Where the case of Lambeth starts to muddy the waters is the status of conditions which had previously been expressly incorporated onto the face of an earlier variation to the original permission, in this case a 2010 variation. And here, in comments which were strictly speaking obiter, that is, they didn't go to the matter in issue in the court's decision, various statements are made about the ability of conditions attached to that earlier 2010 permission to continue to apply to a fresh Section 73 or 42 variation in 2014, even where there is no reference at all to those conditions on the face of the new permission. It was said to be a matter of construction whether the later permission was compatible with the continued effect of an earlier permission. If it was, the condition would apply to that later permission. So where does all of that leave us? Well, it certainly muddies the waters and sows some confusion. Certain situations, I think, will be clear. Where the effective words of a condition are written onto the face of a decision notice, they will probably be held to control the use of land. More complicated will be situations where a varied permission fails to mention previous conditions at all. In that case, they might still be relevant, but it will be a question of construction. And with that, we'll leave Lambeth there and pass over to Lindsay. Thank you.
Thanks, Alex. So speaking of applications, Section 42 applications, the legal procedural matters which arose in the 2020 decision of City of Edinburgh Council against Scottish ministers are particularly interesting. In 2003, the Council granted outline planning permission for a mixed-use development at Granton Harbour in Edinburgh. Among other conditions, Condition 1 required reserved matters applications to be made within 15 years. Developers acquired the site in 2014 and in March 2018 sought to amend Condition 1 to extend the period for approvals. The developers appealed against the Council's failure to determine the application. Developers argued that there had already been significant investment and the extension of time would facilitate the continued regeneration of Granton Harbour. The Council argued that the application was for a new permission and should be assessed against current planning policy, and the Council didn't consider the development to comply with the local development plan. In July 2019, the reporter allowed the appeal, and the deadlines in Condition 1 were extended for a further 5 years, and the other conditions of the 2003 permission were reproduced. The Council appealed against the reporter's decision, which is an unusual situation in itself. The Council and Scottish ministers then entered into a joint motion in which they agreed the appeal should succeed and the reporter's decision should be quashed. However, the developer sought to defend the appeal and the court refused the joint motion. The appeal went ahead without the participation of Scottish ministers. This might seem odd, but it should be remembered that planning decisions are a matter of public law. Ensuring that decisions are lawfully made is of importance to the wider public, not just the appellant and the respondent. There's always a risk that when a planning appeal is taken to the Court of Session, the court won't allow that appeal to be later withdrawn or settled, and this is a prime example. Turning to the substantive issue, Section 42 states that in considering an application, the planning authority must consider only the conditions subject to which the permission should be granted. However, the Court of Session recognised that as a grant of new permission, a Section 42 application must also be determined in accordance with the development plan, unless material considerations indicate otherwise. The Court considered that the situation on the ground, in this case that the development had been substantially implemented, could itself be a material consideration, which may indicate that new planning policy should not be enforced with the same vigour which may be appropriate for a new planning application or for a Section 42 application where the development has not commenced. The case essentially became a reasons challenge, but the court held that the reporter's decision letter is clear and concise and to not leave the informed reader in any doubt about the reporter's reasons. He had exercised a planning judgment that, given the support for the granted redevelopment in the LDP and material considerations, such as implementation of the permission and continuing development, the time for approval of the remaining reserved matters ought to be extended. On that basis, it was unnecessary to engage in details about challenges in other aspects of the LDP, which would not have altered his decision. Our next case is a very recent one from 2021. Mcintyre against Scottish ministers was an appeal by objectors to the Court of Session against a reporter's decision to grant a certificate of lawfulness of a proposed use or development, known as a clawpod, for use of a residential property as a house for up to 4 children with 24-hour care. In this case, the Church of Scotland applied to Stirling Council for the clawpod in March 2019. The Council refused the application in June 2019, and the Church appealed the decision. Care for the children was to be provided on a shift basis, with 3 staff members on each shift, and a staff member sleeping over each night. In refusing the clawpod application, the Council had taken the view that the proposed care provision would add 3 additional occupants on a 24-hour basis, bringing the total number of residents to 7 and outside the scope of Class 9. The reporter considered whether the staff members should be defined as residents, noting that the order distinguished between residents living together and the care being provided to them. The reporter concluded that the carers would not be residents, as they would only attend the premises to work on a shift basis. The proposed use of the house therefore fell within Class 9, and the reporter allowed the appeal, granting the certificate of lawfulness. The appellants who had objected to the application appealed the reporter's decision to the Court of Session, and the question for the court was whether the proposed use of the property fell within Class 8, residential institutions, or Class 9, houses. The appellants appealed on the grounds that the reporter had misapplied the order and guidance set out in Planning Circular 1/1998 use classes by not including the carers when determining the number of residents for the purposes of Class 9. The circular's guidance in relation to Class 9 refers to use by people living together as a single household, as you can see on the slide, and suggests that the case of small residential care homes, staff and residents will probably not constitute a single household, and the use will therefore fall within the residential institutions class. However, Class 9 itself does not, as you can see, actually state that residents must live together as a single household. The reporter in their decision had touched on this inconsistency between the 1997 order and the circular, and the court concluded that paragraph 36 of the circular put a gloss on the terms of the order, which was, in the court's view, quite unwarranted and appeared to proceed on a basis of a misunderstanding of the words of the order. The court was clear that planning circulars are just guidance. While they may be a material consideration, a government circular cannot supersede statutory provisions passed by the legislature, nor can it restrict, qualify or extend statutory provisions. The Appellants Council had referred the court to a number of English authorities, and as you can see on the slides, the English equivalent of Class 9 in the 1987 order does refer to single households. However, given the terms of Class 9 of the 97 order, the court did not consider the English authorities to be relevant. The court concluded that the reporter's decision was consistent and correctly applied the order. The case clarifies the law in relation to the application of Class 9 to children's care homes, and the court's commentary on the circular and its applications guidance echoes the Supreme Court in the 2017 case of Aberdeen City and Shire Strategic Development Planning Authority against Elsick Development. And this appeal certainly acts as a cautionary tale in relation to relying too heavily on what is stated in the circular where it is inconsistent with legislation. Moving on to a second interesting case from earlier this year, I'm going to turn to Ogilvy Homes against Scottish ministers. And I'd like to start this case off with our second poll, asking whether you think that in general there is consistency in decision making by planning decision makers, yes or no. In this case, Ogilvy Home appealed to the Court of Session against a reporter's refusal of their appeal against North Lanarkshire Council's refusal of their application for a proposed housing development. Ogilvy Homes had had 2 previous applications for housing development on the same site refused by the council and by reporters on appeal. A 2015 application was refused by the council on the basis that proposals were contrary to LDP policy DSP4 parts 3A and 3F. As you can see on the slide, DSP4 sets out the council's policy on quality development, and part 3 relates to design and amenity. On appeal, the reporter disagreed with the council and concluded that the proposal did comply with DSP Part 3, but refused the appeal on traffic grounds. A second application for the same proposal, but with amendments to address traffic concerns, was made in 2017. However, in the interim, construction of a separate housing development across the road had commenced, and the council refused the application on the basis of DSP 4 Part 3F, considering the proposal would be detrimental to the amenity, character and setting of the surrounding area, including the new development. On appeal, the reporter disagreed with the council and concluded that the proposal did comply with DSP 4 Part 3, but refused the appeal on the basis it was contrary to DSP 4 Part 2, which relates to protecting the environment due to the loss of mature trees and potential impacts on bats. Finally, a third application for a proposal with a reduced number of houses was submitted in 2019. Again, the council refused the application on the grounds of residential amenity impacts. The third appeal was again refused, this time on the basis that it was contrary to Parts 1, 2 and 4 of DSP 4, due to the loss of open space and features of local natural interest. Ogilvy Homes appealed the reporter's decision to the Court of Session. The court found that the reporter had erred in his interpretation of DSP 4 and other LDP policies. However, the court was primarily concerned with the failure of the reporter to take account of the previous planning decisions and to explain why he'd reached a different conclusion. While the application of policies requires planning judgment, and authorities and reporters are not bound by previous decisions, the court confirmed it is important for decision makers to have regard to the principle of consistency in decision making. Quoting from the decision, the court said, if a reporter seeks to depart from the reasoning in an earlier decision relating to the same site and on the same issue, it is incumbent upon him to explain clearly why he is departing from it. It is not sufficient to recognise the existence of the earlier decision and to state that he or she must reconsider the proposal on its merits. The court acknowledged that where an application or appeal is refused on specified grounds, it's not unreasonable for an applicant to have harboured hopes of obtaining permission if they were able to overcome the identified issues. The lack of consistency meant the goalposts were shifted each time. Turning to our poll results, there's an overwhelming feeling, I think, that there isn't consistency in decision making, and to be honest, that's kind of what we were expecting. Obviously, people tend to remember the decisions that jar with them, but there's no doubt that consistency in decision making and giving reasons more specifically has been something of an issue in recent years. Gladman, the 2019 case of Gladman developments against Scottish ministers was also about consistency. I'm sure we all have our own examples. And speaking of the 2019 Gladman case, the court in Ogilvy effectively reiterated their conclusions from that case, which made clear that previous decisions must be taken into account and departures must be clearly explained. And while we're on the subject of Gladman, it would be impossible to do a case law update without mentioning the 2020 Gladman developments against Scottish ministers case, which we were involved in on behalf of Gladman. I won't rehearse the full story now, as I'm sure most of you are well aware of the case. Essentially, it involved the application of the presumption in favour of development that contributes to sustainable development, which was introduced when Scottish planning policy was adopted in 2014. Key issue was whether a tilted balance should be applied in the determination of applications where the presumption is triggered, and the court held that where the presumption was a significant material consideration, the adverse impacts of the proposed development should significantly and demonstrably outweigh the benefits before an application or appeal should be refused. In terms of whether a development contributes towards sustainable development, the court also stated that a housing development which will remedy to some extent a housing shortage would almost inevitably contribute to sustainable development. The court also confirmed that the assessment of housing land supply should be made against the local authority's housing land requirement rather than its housing supply target, the housing land requirement being the housing supply target plus a 10 to 20% generosity margin. Matters have obviously moved on with SPP since the Gladman decision, and on 18th of December 2020, Scottish ministers published amendments to SPP, which essentially changed those elements of SPP, which the Court of Session had clarified in relation to the presumption. Those amendments are themselves currently under challenge in the court session, and we're acting for one of the challengers. So this isn't necessarily the end of the story, and I expect we'll see you all back here in future to discuss the outcome of that case. But the Gladman decision does set the scene for the court challenge in Mcintyre and Mickle Homes Limited and others against Inverclyde Council. Mac and Mick, Miller Homes, Calla, Persimmon Homes and Wallace Land jointly raised a challenge against Inverclyde's adoption of the Inverclyde Local Development Plan. While the challenge was against the council and their adoption of the LDP, it centred around the Housing Land Supply Targets and Housing Land Requirement chapter of the LDP examination report and many of the examination reporter's conclusions, and so Scottish ministers took part as an interested party. There was a lot of detailed submission about housing calculations and methodology, which time doesn't allow me to go into here, but the court considered it clear that SPP requires local development plans to allocate sufficient housing sites to ensure the housing land requirement, rather than the housing supply target, could be met. And this is consistent with the Gladman case, and amendments to SPP haven't changed the requirement for development plans to allocate a range of sites to meet the housing land requirement. Policy 17, there on the screen, of the LDP set out the council's policy to be applied where there was a housing land supply shortfall. The examination reporter had essentially failed to come to a conclusion on housing land supply, relying on Policy 17 as a safety valve. The court found that this was not an appropriate approach, and that Policy 17 was not sufficient to demonstrate compliance with the requirements of SPP and the Strategic Development Plan. The decision highlights that planning authorities need to ensure that they can demonstrate they have allocated sufficient sites to ensure compliance with SPP and Strategic Development Plans where relevant. If a reporter is unable to make conclusions on housing land supply, care needs to be taken not to place an over-reliance on a safety valve policy, such as LDP Policy 17. So we have our final poll for you now. Should Scotland have a tilted balance where a development plan is out of date, or there is a shortfall in housing land supply? So the options for you will be that it should have a tilted balance in both situations, that there should be a tilted balance where the development plan is out of date, that there should only be a tilted balance where there's a shortfall in housing land supply, and no, there shouldn't be a tilted balance. While that poll is going on, I'll just finish up talking to you about the Inverclyde case. So the court also concluded that the reporters had been wrong not to take account of the 2018 housing land audit, which was on the face of it relevant to the assessment of housing land supply. The housing land audit had not been published when the LDP was submitted for examination, but became available during the examination process. Representations had been made on the LDP, on the housing land audit by Homes for Scotland, which it was not clear had been taken into account by the reporter. This reaffirms that potential relevant evidence must be considered, or reasons given for ignoring such advice. Overall, the court found that there were a number of material errors in the LDP examination report, and the relevant chapter of the LDP was therefore equally materially flawed, and the court therefore quashed LDP Chapter 7. And this leaves Inverclyde Council in the unusual and unenviable position not currently having development plan policies in relation to housing. The Council are currently conducting an LDP review. Consultation on the main issues report ended on 31st January 2021, and the Council expects to publish its proposed plan in May 2021. So checking back in with our poll results, it looks like there's a strong favour for a retention of a tilted balance. Craig, I think you have some thoughts on this.
Yeah, I meant to say at the outset that when I was introducing the poll that there were no wrong answers to any of these questions, and I was going to carve this question out of that. But I don't think I needed to worry. There's a certain irony with this for us, given the nature of the SPP challenge that is underway at the moment. But equally, not a huge surprise that there's overwhelming support for retention of some form of tilted balance vast majority of people obviously think that we should retain the tilted balance to apply where the development plan is out of date and there's a shortfall. Others looking at a slightly more refined approach, but yes, that's somewhat at odds with the consultation responses that government got back. But again, not hugely surprising to be said. Lindsay, thank you for that. I'm going to now pass back to Alex if I can, just to cover the last two cases that he had on his list. Just hand back to you, Alex. Thank you.
Thank you both. The next case is stepping away from the tilted balance. It's one from the Information Commissioner, so a slightly odd source of decision making. This is the latest case to illustrate a point which can have wide-reaching implications for developers performing functions in our privatised economy which may at one time have been the reserve of the state. So the case is Eon UK, and it relates to a request from Fish Legal, more about them later, in 2017, for information relating to the Rampion offshore wind farm under the Environmental Information Regulations. Now, back to Fish Legal. They are famous, at least in EIR terms. They're a famous fishery rights group, which has been the subject of a number of cases, tribunal decisions, which have helped shaped the EIR regime. Now, if we can roll on to the next slide, please, Lindsay. Eon did not respond to the request from Fish Legal. Its position was that it was not covered by the regulations. The Commissioner then issued an information notice, which was appealed and has been the subject of separate upper tribunal proceedings. And back in the realms of this case, 3 years later, the Information Commissioner went on to hold that Eon was a public authority for the purposes of the EIR regime. Now, the decision is notable because it very clearly takes the reader through the circumstances in which a private company may be held to be subject to that regime in England and Wales. And I'll come back to that later. Eon had been the applicant for the Rampion offshore wind farm, which had received development consent by way of a statutory instrument. However, by the time of the request from the Commissioner was satisfied that Eon had divested itself of any interest in that project. It did, however, hold an electricity generation licence under the Electricity Act 1989 at the time of the request, and continued to hold a gas supply licence under the Gas Act 1986. The generation of electricity and the supply of gas are public services carried out in the public interest and with an impact on the environment. The Commissioner found that by virtue of holding the licences, the licence holder was vested with special powers beyond the normal rules of private law. For generation licence holders, the powers included compulsory purchase and acquiring wayleave powers. And for the supply licence, there were powers to obtain warrants for access to property through the Magistrates' Court. On the unusual facts in this particular case, Eon had also in fact revoked its electricity generation licence. However, on the very limited powers of the gas supply licence, it was held to meet that definition of a public authority. Now, back to the difference between the regimes either side of the border, it's important to note that the language of the equivalent regulations in Scotland do not expressly include one of the limbs from the English regs, which were determinative in this case, despite the common EU source code for both sets of regulations. And perhaps because of that, it won't be a surprise to know that there is a lot of overlap between the English and Welsh regs and the Scottish equivalents. So I think you can expect to see this line of thinking at least emerge in decisions in Scotland as well. The practical takeaway is that where an entity benefits from a licence under one of the regulated utility regimes in the UK, I think they need to think very carefully about whether they will be held to be a public authority under the Environmental Information Regulations. There are all sorts of implications really for that position in the way in which those entities should be managed from a corporate structure perspective. And on the other side of the coin, from the public's perspective, it confirms that the EIR regime is opening up public access to information around these functions like never before. Now, we finish with a final case about the limits of the Section 42 or the Section 73 process and the ability to obtain planning permission without compliance with conditions previously attached. In Finney and the Welsh ministers, the Court of Appeal was asked to look at the use of Section 73 applications, so equivalent to Section 42, to vary a planning condition in order to change the parameters of the description of development in the underlying permission. The developer here had permission for 2 wind turbines that were described as with a tip height of 100 metres in Carmarthenshire. The permission also included a condition that the development was to be delivered in accordance with the approved plans, one of which showed the turbines would have a tip height of 100 metres. The developer applied under Section 73 to amend the condition to permit a tip height of up to 125 metres. That was allowed on appeal by the inspector, and the words with a tip height of 100 metres were removed from the original permission's description of development. In the courts, it was argued that the Welsh minister's inspector had acted outside of the scope of their powers by granting planning permission with a varied description of development. Now, the High Court upheld the inspector's judgment. In the Court of Appeal, Lord Justice Lewison gives a very useful judgment, bringing together the various strands which had emerged in High Court cases over the years concerning the use of Section 73. In particular, he noted that at first instance, the High Court had felt itself constrained by the decision of Mr. Justice Singh, as he then was, in the case of wet finishing works, where the approach to what was said to be permissible under Section 73 was that it enables variations which do not give rise to a fundamental inconsistency between the operative part of the permission, so the description of development, and its conditions. Now, what amounted to a fundamental inconsistency was said to be a question of fact and degree. That approach was not followed by the Court of Appeal, nor were arguments from the Welsh ministers and the developer that the Wheatcroft test should be applied, which relates to what is permissible by way of variation to planning applications prior to the grant of permission and comes into consultation and those sorts of issues. Instead, the court approached things as a case of simple statutory interpretation. On its face, Section 73, Section 42, refers to development taking place without compliance with conditions previously attached. That reference is said to relate directly to breaches of planning control arising from a breach of condition. The purpose of Section 73 is to give relief from such a breach. The section goes on to refer to the planning authority considering only the question of conditions, but simply the description of development is entirely off limits. It's only the conditions which matter. Now, to be entirely blunt, the decision in this case is a good example of case law removing a layer of uncertainty that had been built up by past decisions, blurring the boundaries of a relatively straightforward statutory provision. Well, it's easy to say that in hindsight, of course. I think the practical message coming from this case is clear, which is that it is only the conditions which matter. However, I am also acutely aware that the approach in this case, and the approach it overruled, is giving rise to some real problems with accepted practice, where this approach has routinely been followed by local planning authorities and developers around the country. So it's a case that creates its own issues. And with that, we've come to the end of the cases that we aim to run through today, and I'll pass back over to Craig, where I think we're going to have some time for a brief bit of Q&A.
Thanks, Alex, and thank you for that. And whilst I collate the Q&A, just that last point that you make on Finney and the practical application of it, and how the courts have clarified a position that had become blurred. I think I picked up on your use of the word hindsight there, because what strikes me about it is that a practice had very much developed in recent times where that blurring had basically taken hold, and in particular in a Scottish context in wind farm development, where it had until recently been fairly common for developers to amend development, specifically revisit a tip height restriction, which was invariably imposed both as a planning condition but also included in the description of development, and Section 42 applications had been used fairly regularly to revisit that and amend the condition, and no one, in truth, had paid a huge amount of attention to what was said in the description of the development. Finney, and many people on this webinar will know this, but Finney got quite a lot of attention after it was issued in the Scottish market, and I think it was the Warbrax decision from June 2020 where the reporter effectively adopted Finney. That was an application to amend, fairly modest amendment to existing tip height restrictions for the Warbrax wind farm scheme, and the reporter refused the application, basically applying the Finney approach and saying that it wasn't open to him to vary the condition because the tip height restriction was in the description of development. And he did that notwithstanding the submissions from the developer that this was a well understood, and they were right, well understood approach in Scotland, had been applied in other appeals not very far away from the Warbrax scheme, and had been applied successfully. And it's caused quite a lot of issue for people having to revisit their consenting strategy. Ironically, perhaps, it may be easier to go down the non-material variation route than it is actually to go down the amendment of condition route, which I'm not sure is the intended consequence of any of this, but that is at least one of the options for people. In terms then of questions, I'll just pick up straight with you if I can, Alex, because we've got one back at the beginning on Lambeth. Question is, does the Lambeth decision have any implications for the legal status or the application of informatives that you find at the tail end of a planning permission?
I think probably the answer is not. I think probably the answer is no. There's no, strictly speaking, there's no change in their status. The status quo is respected. I think in practice, they're going to be looked at with increased scrutiny in order to inform that that approach that Lord Carnworth outlined in the Supreme Court, which is that it's what does it mean to a reasonable reader, and looking at the document as a whole in its context. And yes, clearly the informatives are going to play a role in that process. The particular decision notice at issue in Lambeth was an odd one. The condition had been the varied condition, as it was called, had been taken out and had almost been repeated as the description of development for a Section 73, Section 42 consent. And it's so it appeared on its face. But I think probably the courts are going to be relatively open to any words which appear on the face of a permission in that way.
Yeah, I have to say I do find it odd that when Section 42 applications are done, and we had this, I suppose you'd say, when there was the Granton decision, that the decisions are not simply repeated into the next planning permission that you're issuing. That to me would seem to be the safer thing to do, rather than rely on what may or may not be implied into the consent, just to cut and paste really the conditions that are already there. And in fact, that in a Scottish context, that's what the Development Management Circular tells local authorities to do. I suppose, Wendy, that in part was what happened at Granton.
Yes.
And I've got another question here, which I think I'll take, which is if there's any update on the challenge to SPP and the timescales for that. There is, yes, it's still in process, so I won't say a huge amount on it. There was a permission hearing last week, and the Lord Ordinary has allowed all grounds of challenge to go ahead. The case is under expedited procedure, and so we're hopeful that the hearing will take place mid-April, and a decision should be available, I'd have thought, in the late summer perhaps, start using seasons rather than specific timescales, to be honest. And there's a follow-up question on that, so which on is there a risk that tilted balance arguments become too focused on housing and have unintended consequences for non-residential development? I don't know if either of you have a view on that.
I think that was something that Scottish Renewables and other renewables developers were concerned about, and that concern was coming through. That the consultation was, and the changes to SPP were focused on residential matters and didn't quite take the potential impacts on renewables into account. Although there is, of course, the slightly different relationship where a renewables development is a Section 36 consent, and a slightly different relationship with SPP there.
Yeah, that's a good point. It's important to remember the different consenting regimes that apply. But I mean, to pick up on that point, one of the criticisms, I think, of the original consultation was that it had advanced a position that was really based on and looked at housing, but was proposing changes to policy that were much broader than that. I personally think that there is a risk that the concerns that government clearly have about the tilted balance in a housing context are driving changes to policy, and in so doing are removing some quite useful levers for decision makers in other types of development. In fact, it is a case of baby out with the bathwater on that one. Just looking through if there's any other questions from anyone. I think we're running short of time today, so I think, as I said at the outset, we will endeavour to try and come back to people on their questions that we haven't had time to get to this afternoon. We'll come back to you separately on those, if that's okay. All it remains for me to do is to thank both Lindsay and Alex for their time and contributions today. Thank you both very much. To thank also the Burgess Salmon team for organising this, and of course Paul at WebEx for keeping us all right on the webinar and running the polls so successfully. Enjoyed that. We have one last favour to ask of everybody, which is before you sign out, if you are able to complete the short questionnaire, that would be much appreciated. It helps us inform what we'll do in future sessions. So thank you all very much for signing in today. I hope you have a good afternoon, and speak with you all soon. Thank you very much.